Esteemed colleagues, we are starting the proceedings of this session, the application of antitrust law under modern economic conditions. And before announcing the participants of this session and the panelists, I would like to say a few words concerning certain aspects related to antitrust regulation. Firstly, for many centuries, in this way or that, the states defined their approach to regulating market economy. It was by British economists, starting with Adam Smith, who said that the government must be a night watchman, not to interfere seriously into regulating economy. There's an invisible hand that will put everything in its places. However, history demonstrated that the invisible hand does not always cope to manage to regulate all the aspects of the market, and sooner or later it arises to all the governments that additional mechanisms are necessary. One of such mechanisms is the antitrust or anti-monopoly system, which defines the limits of that regulation. There is another idea ascribed to Spinoza, and which later was repeated by Hegel, Karl Marx, and Vladimir Lenin, and that is that freedom is a perceived necessity. When we talk about an economic liberty, that liberty may not have an unlimited nature, otherwise it will become chaos. So these regulations do form the economic liberty and define the parameters of economic regulation. Our objective is to formulate the limits to which a government may interfere into economic relations. And what are the limits of economic liberty? How do we build an efficient antitrust law in modern conditions? The efficiency of economic development of this country depends on our answer on that question. We defined different issues for discussion. This is the relationship between government and the private entities in regulation, the limits to the application of antitrust law to entities having exclusive rights, and whether the system of regulation is built correctly in the Russian Federation, how it is built in the world, and also the issue of compensating monopolies for losses. Esteemed colleagues, I would like to introduce our panelists who will try to answer these questions. The keynote speaker, is the head of the Federal Anti-Monopoly Service, Igor Artemyev. Participating in this session is also the senior lawyer of the Committee for Competition from South Africa, Mayonga Buhesibake. The former judge of the Supreme Arbitration Court, Oksana Gvozdilina. I would also like to introduce our speaker, the director of the Department of the Eurasian Economic Commission, Sergei Maximov. Another speaker is a partner in Latham and Watkins, Lars Kjølbe. Another speaker is the head of the General Yegorov, Puginsky, Afanasyev and Partners law firm Anna Pugareva. And then a lawyer From Pen and Piper, Alexei Dobrynin. And also the managing partner of Kaminska and partner Tatiana Kaminska agreed to participate in this discussion. Esteemed colleagues, we will start our session, and I would pass the floor for the keynote presentation to the head of Russian Anti-Monopoly Service, Igor Artemyev. You're welcome, sir. Thank you very much, Sergey. Good morning, esteemed colleagues. Well, first and foremost, I would like to start from the venue where we have been meeting many times. There has been a lot of events in this building notable for Russian history, and one of them, strange as it may seem, does have to do with anti-monopoly or antitrust law, to our activity, and it is related to the fact that we are in the building of the former General Headquarters and Winter Palace. And as you know, this was for a long time the residence of Russian Tsars, and Nikolai I, who reigned for a long time, was the signee to the punitive code of the Russian Empire. And it said that the agreement between merchants who trade in the market were to be punished by up to 8 months of prison for a price agreement. Well, quite often that article was not very often used at that time. But this means that even at that time our ancestors understood that limiting competition in the market is necessary, that monopoly in the market is a crime, and it was prosecuted. So when capitalism was developing in Russia, even then this subject was quite important. A lot of time passed. The Soviet Union forgot about that for 80 years. And then the ideas and the issues returned with the new advent of capitalism. And during the last 20 or 30 years, we've noticed globalization of economy, the appearance of cross-border interest and cross-border markets, which made a Russian government think a lot about how to make our law intended not just for domestic market, but how to use the best world practices and how to consolidate Russian law with international laws. And the first laws about that were passed in the early 90s. Since that time, there has been a serious reform, and we can look at the second slide. We actively collaborate with ICN and with other international organizations, and OECD in particular. We converge our law in such a way that it meets the requirements of OECD, which was recognized by OECD 2 years ago after their long collaboration with the Russian government. And the management committee, the ICN, Russia has been part of ICN since 2007. We actively work in anti-cartel legislation. This is a very important issue for us, and one of the biggest issues for us is struggling against international cartels. Quite a lot of countries forbid cartels in their territories. However, in the international grounds, the cartels are not prohibited. They are even sponsored. And quite often, this leads to very fraudulent practices. And as a result, we call it fraud on a territory of one given country, but we fail to call it fraud when it happens on an international arena, when it's done by transnational corporations, as is intended typically against developing countries. So we are going to discuss this within this session and at this legal forum. The next BRICS meeting in South Africa will also raise this issue. We'll be discussing this issue with our BRICS partners, and then we will be discussing it with all the ICN members and with all other countries. The Russian government has established a roadmap. In fact, this means harmonization of our law with the best international practices, but this is its final part, because the major elements were introduced several years ago, and we are working actively on the latest recommendations by our legal advisors, of the biggest international law firms. Certainly, we take the judicial practice into account, and we do take into account the decisions by the higher arbitration court, which were the source of ideas and laws for us, because the legislators very actively supported this practice and this idea. And today we would like to streamline this work, so we formed the fourth anti-monopoly package. A big number of amendments to our law on competitions, and I have some news. Yesterday, the government of the Russian Federation has finally approved the fourth anti-monopoly package, and we hope that the government committee on legislation will submit it to the parliament, and we think for the second reading, and we think that while the lower house is working on it, we will be able to pass it by July, so that this will be a great victory. This will be our great contribution to the world's best practices, and we will have to meet very high standards described in the fourth anti-monopoly package. We will need to teach our students, teach our lawyers to apply them and to put all that into practice. I will not be speaking in detail about that package, because probably we won't have time for that. We have a lot of speakers for today. But if you open slide 7, you will see that we finished the harmonization of our criminal code. Russia provides a criminal liability for cartel. We haven't yet been witnessing, well, no one has been ever sent to prison yet for that, but there have been some suspended sentences under Article 178 of the Criminal Code. So it is used. Based on our consultations with the legal and business communities, and after looking into OECD standards and after consultations with our partners in Europe and worldwide, we decided to refuse from administrative prejudicial, and we have significantly raised the threshold of grave damage, so that the SMEs do not fall under this article. So we will be oriented towards big trespassers, big wrongdoers, who afflict serious damage to the national economy. And I believe that if we investigate those violations seriously with police, then the wrongdoers will be sentenced to serious terms. So we have harmonized this article with the international practices, and all that has already happened, and the Parliament and the President signed this article, and this new version of article is already in force. And I would like to thank our MPs and the President who signed it, and the government who approved this article and discussed it in the Parliament. Slide 8. I just want to note one thing. This is the society is oriented towards crime prevention. Several years ago, we had to sue and to investigate, and did that without any warning. When we found incidents of violating the law, we had to investigate, and if there was a complaint or a claim, the only thing we could say was yes, we do investigate, or no, we can't see this as a crime, and we do not investigate. Otherwise, the corruption would be on the rampage. But the lawyers and the defenders of businesses came to us and told us that the prevention institute should be tried as an experiment. We made certain amendments in the law, and actually this is a very good institution. So after getting a warning from us, and in 100% of cases we do send warning, we show the yellow card like FIFA does. So we cannot use sanctions until we warn, and there is no alternative to that. Under certain articles of the law, for using a dominant position, we warn. And actually 80% of the companies that get that warning, they comply with it. 20% think we are wrong, but then the matter is brought into court. Then, according to the administrative code, sanctions are used. So we really liberated ourselves and the courts from 4/5 of our work, and actually we did not consider a lot of minor trespasses. Suppose the store was not connected to the electrical mains. Now they are connected, and they didn't have to go to court for 9 months. So this is a kind of first aid, and a very rapid aid. So we would call it a soft approach. But the fourth package actually spreads this warning idea over practically all the articles except 2. The use of somebody else's trademark or the use of a very high monopoly price. And the reason is, in this case, that warning doesn't make sense because we have to respond rapidly in this case. So in these 2 cases we will not warn. So that approach really changes all of our strategy. From a punitive body, we become a body of that warns, and actually we have been fighting this struggle, and we also struggle against the authorities who also violate the competition laws. This is a specific feature of our law. We have to sue the authorities who discriminate against companies or people. So quite a lot of those cases are cases against governors or ministers, and we have to continue suing those authorities. However, based on the 4th anti-monopoly package, the number of cases against companies will be reduced 5 times.
And then we're going to concentrate on the most biggest cases. We'll be dealing with our beloved Gazprom, beloved Russian railroads, and any other large corporations. And I'll probably list all the state-owned corporations. Today we're dealing with Gosavtodor company quite seriously. and I'm sending our best regards to Avtodor. I hope they're hearing us. I hope they're thinking about us. I hope they're dreaming about us. And I think it's just a tiny warning. It's a tiny warning, just. I hope them to get upset just a little bit. And during the next legal forum, we're going to make them even more upset. So these are the kind of things we're going to deal with now, but not with some minor fish or small fish. We want to catch big fish. And let me tell you one more thing. The government has decided that we should introduce immunities for SMEs under the edge of this package, and we did a lot for this law to be adopted in fall this year, and is going to be endorsed. And yesterday there were several discussions, and the basis for this immunity is very simple. If a company is not a part of a holding, it's just a family business, or imagine a person just owns one small shop next door, or just a small plant, a candle factory or whatever, and the turnover is no more than 400 million rubles, well, $10 million, that's for our foreign guests in here. We won't come to them at all. We won't knock on their door. We won't check them, and they will have an immunity. They will be secured from us, and we won't use the article of violating dominance position. They won't, though, be able to join cartel, but all other things, well, they can do it. Even some of the things that others are being punished for, and we will be just again catching the big fish, and will not be fretting over the small stuff. There are a couple of more serious problems that I should really talk about now, and I'd like to talk about the international policy. Can we open, please, slide number 17 there? Actually, we're very active in terms of international cooperation. Well, lots of former Soviet countries are our colleagues because we work with them quite actively and quite intensively. We have joint headquarters. We had a number of joint investigations in 9 countries of the former CIS countries, and we had lots of good practices, best practices. For example, pricing for oil products investigation, or roaming for telecoms, grain market, medications market, and we do lots of joint efforts, lots of joint work, and I think this work is going very well. And now what we're doing in the framework of the customs union of Russia, where there's customs union, where there are 5 countries and there are applications for many more, I think we've created a very good methodological base and methodological background to really do the benchmarking. And I think the things we have done in here can later be extrapolated to 5 or even more countries. And we hope to match our methods with the methods of other BRICS countries and do the benchmarking there. And we try to learn a lot from various documents that are being born in an international arena, say in the OECD or in many other organizations and associations. And I think the unification has reached a certain level in here. And I hope that soon the Eurasian Anti-Monopoly Committee will start making decisions independently from us that would have an overarching force over the 5 countries of the customs union. These Anti-Monopoly Committee, Eurasian Anti-Monopoly Committee, is quite active already. So there are many cases that we've initiated, and we are following through. This slide, for example, shows what our international working group has done in terms of regulating oil prices and oil products. Everybody knows the Platts and Arnold's agency, right? Everybody's familiar with this agency, don't you? And the slightest and the softest thing we can do is we can say that the methods by which global oil prices are being made requires certain corrections. I think that's the mildest thing we can say. And we remember the scandal that's rolled over Europe about the Libor stake, right? 20 countries today joined in forces together with us, trying to research and investigate how world prices for various commodities are being formed. This price, just a tiny difference in oil price or in oil product price turns into millions of losses for many companies and for many countries. And we presented a report about this issue during the OECD IP meetings, and this topic is quite interesting, and we're very thankful to all the 20 countries who joined in this project. We're not trying to prioritize those projects, right? The US, the UK, well, they're not politicizing over these projects. The US, the UK, many CIS countries are doing it hand in hand, and that's quite interesting. And we have a very good working group jointly with our colleagues from Italy, and we've unified our approaches, and we started analyzing, matching our market indicators, what happens with vital medications in the countries. And now this group has grown out to 16 countries. And the essence of this approach is very simple. We have a platform in the internet, and anti-monopoly bodies can put their prices on this platform. They can state how much different batches of medications cost, and at any given day we will be able, I think very soon, we'll be able to unify the methods, and we'll be able to just by one click have a look at how much this medication costs in Italy, how much this medication costs in Russia. And unfortunately, Russia is losing in this. Although the salary level, wages are very low in the country, the cost for medications is quite high. And the social disparity, it has to bring birth to important legislative initiatives. 12 countries, and I'll talk about that later, 12 countries are now investigating roaming prices. Why roaming is becoming so expensive for us? Because the cost of the service is really nothing, it's peanuts. And we've already initiated and brought charges against some of the associations in here, and 10 years ago the prices dropped down again, and now they've again grown. And now we're being fed with stories by these companies that the exchange rate has changed. Well, if, for example, the service cost, say, 0.01, and now it costs 0.02, it doesn't really matter, because for us it's still quite expensive. And I think we need to be expecting some cases and some charges brought against the telecom companies and operators across the whole CIS. Many companies that recently were bold enough to state that they're going to raise tariffs, I think they're going to be quite careful and quite accurate now, because we are soon to be going down on them. So these things, they bring about important initiatives, and these things, they trigger important questions to be discussed, that we should discuss here in this forum. How does an anti-monopoly law connects with the IP law? In our fourth package, we suppose we wanted to make a very first and a very timid attempt to try to at least describe this connection, but there's been a very serious protest against from the companies, from the legal community of Russia, and we decided to drop off any of the activities in this regards. And what happened? When a year ago we dropped any attempts to write down quite simple and clear-cut things in our anti-monopoly law about the IP rights protection, just stating clearly that any goods turnover that are protected by IP is fully has to fully be in line with the anti-monopoly law, and when the goods are already in circulation, you cannot go for cartels, you cannot violate your dominant position, and so on and so forth. And there are no doubts that if a good has been put into circulation, if the goods have been put into circulations, they have to abide by anti-monopoly law. This is already evident in the court practice. And although it's not quite evident, I'm really amazed at what our courts do, because in this time of uncertainties, in this times of artificial uncertainties, they still managed to make the right decisions. And there's now a clear-cut court practice that other countries can use. But dropping some of the activities a year ago, when we were preparing the fourth package, in some goods categories like medications and so on and so forth, some companies stopped supplying goods to Russia by excusing themselves using this IP loop. There's been a couple of cases when pharmaceutical companies stated we're not gonna supply this medication to Russia, but this medication, for example, saves lives of kids. What any government will do, or any anti-monopoly body will do, will take everything possible, will make everything possible for this medication to finally end up in this country, even if we have to change the law or sanctions, the sanction regime. For some reason, it turned to a different angle, and it started impacting the things it shouldn't impact. For example, many companies stop supplying vitally important goods to the countries, and these are brands, these are intellectual property. And the owner of this IP says, this is my property. If I want, I will supply. If I don't, I won't supply. If I want, this price will be astronomical. Or maybe I don't want this good to be circulating in this market. Well, many countries responded to these issues in many different ways. For example, South Africa, they did something with their medications against AIDS. In Brazil, India, China, and I'm just mentioning BRICS countries. I'm not even talking about national legislation of the US, where I think in 1909 the Supreme Court has ruled out that IP rights can also be violated, and charges can be brought against this, and in Europe and so on and so forth. And we've discussed this already several years, and we now understand that in our anti-monopoly law, in our civil code, we need to introduce some additional norms, and that if somebody violates the IP rights, then we can go to court and we can make a decision that we can replicate, say, the same medications by Russian companies, like it was done in India, like it was done in South Africa, in any other way. We should go away, well, if we were beaten this way and we had to drop our soft power, we had to be more rigid, we had to be more bold, because the government will be dealing with this in the nearest future, and I think very soon, together with a wider legal community, we'll be preparing a proposal, and it's actually written on slide number 13. Can we please open that and show it? That's the way it should look. We should fix in our law the right for anti-monopoly bodies to go to court against patent holders on a forced provision of a simple, non-exclusive license for the use of the invention, utility model, or industrial prototype. Of course, the list of such goods or the list of such trademarks should be very limited, but it has to apply for some very vital things, and it can only be done through courts. But that's what we had to arrive, and that's what other developing countries have arrived to, and that's what Russia will arrive to. And this is the consequences of our sanctions, and it's also one of the best practices that we've seen everywhere else. And now I'm going to come to the end. So slide number 19, rephrasing a very well-known phrase about proletarians and their need to unite. Well, as Karl Marx used to say, right? The unification of proletarians led to revolution and very grave consequences. So we hope that communication and cooperation between competitive bodies and anti-monopoly bodies and global markets will lead just to good things, and we have to work together. And we want the sphere to be completely depoliticized, and that's how we see it for now. And we want this cooperation to lead to the fact that joint investigation of international crime. Can we still show slide number 24, because that's where it's formulated in a better way. So yes, anti-monopoly bodies of all countries do unite. That's what we call for. And we understand that the work has to be done jointly, and we want to come back to this convention of fight against international cartels. And let me remind you about our dream that we came a little bit closer to in Russia. We're very close to achieving consensus in the government of Russia. When investigating international crime, we need to go together, we need to join together, and we want an international body to be there, like Interpol, right, that will deal with cases of international crime related to limitation of competition, monopolies, international cartels, and trusts, and so on and so forth. We want to be long-term. If it doesn't happen tomorrow, but if it happens in 5 or 7 years, at least in a midterm perspective, it will already be a very good input by ourselves, because in this way economic relations, business relations, and all the globe will be more fair and just. It will allow developing countries to develop on a fast track, and it will help it will help the majority of the world. It will help specific people and citizens of this world improve their well-being and prosperity. And when we were talking to the aide to Prosecutor General the US, I asked him, the antitrust department that you have, it deals with various cartel issues and so on and so forth, and I asked him, so if we take, I asked him, all those economic crimes that you've investigated, what are the most dangerous ones, do you believe? He said, we believe in the US that cartels does such a damage to the economy that that's the most dangerous crime of all, the most dangerous crime of all. And we can't even forecast now, in Russia, that can be called a cartel country, or the country of a winning socialism. Well, 20 years ago, I think it was right. You might remember that in the 90s we had some reforms. And these reforms, they led to cartelization of whole industries and huge other impacts and consequences. So that's the way we should look at the problem. And by finalizing my talk, I'd like to ask you and call you on talking about the most important things, international cartels and their danger. How does the IP rights and anti-monopoly law match and can be married, and how do various bodies react to different problems we have? An international corporation, of course. And in the end of my presentation, I'd like to say, in this legal forum, that we have many friends across the globe. We have many opportunities to conduct international meetings, to exchange experience, and to do joint investigations. These joint investigations were already done by us together with the European colleagues, with CIS countries. We had bilateral projects with many countries. And my call to anti-monopoly bodies and to all the lawyers and scientists to join efforts, and with this concerted effort to try to create the economy of the 21st century. And the 22nd, because the 22nd century is already arriving, and this is a very important task, and we're making one more step towards this better and enhanced cooperation. Thank you very much.
Thank you very much, Igor. I want to say that this session is directly transmitted on the web, and a lot of friends of ours who may not be present at this session personally have an opportunity to watch it on the web. I would remind you that there would, in the past, thousands of viewers watched our presentations, and later you could download all the sessions from the Legal Forum site during 1 year, and quite a lot of students and practicing lawyers and even judges watched our proceedings. Actually, we are talking to thousands of people right now, and because of that, all our messages reach their addresses very fast, thanks to the internet. But to develop the discussions started by Mr. Artemyev about the approach to domestic regulation and defining the anti-monopoly positions in the country, and concerning the cross-border area, and anti-monopoly struggle is a cross-border thing. A market economy goes beyond the boundaries of one given state, and because of that I would like to pass the floor to our guest from South Africa, senior lawyer, competition committee, Mayenga Mukhisibahi, and I would ask him to tell us about the problems existing in regulating economic relationships in South Africa and how they collaborate on an international level within BRICS and with Russian Federation. Thank you.
Thanks a lot, Chair. Firstly, before I go into our presentation, we would like to thank our Russian counterparts for the invitation and to also give us an opportunity to participate in this forum and to reflect on the experiences with competition law in South Africa. It has been a 15-year experiment for us because competition law in South Africa really started in or about 1998. So we are a fairly new jurisdiction insofar as implementation of competition law is concerned. But a lot of progress has been done and more still needs to be done. I think our starting point is just to, in our reflection, is just to, I think the starting point is just to start with the historical context. The historical context in our country was such that before 1994, which is during the times of the apartheid regime in South Africa, the economy was structured in such a way that you had very high levels of concentration in various sectors of the economy. So there were monopoly concessions during that time, which were granted to various industry players. For example, in the beer market, beer production market, the beer production market was reserved for South African breweries. So such that even today, you still have the same situation where the beer production market is dominated by South African breweries. So the same explanation applies to various sectors of the economy. So those companies which were given monopoly concessions before under the apartheid regime, they continue to dominate various sectors of the economy. And one feature of the South African economy is the fact that cartelization was also encouraged for many, many years in South Africa because of, obviously, South Africa at that time was under international isolation. So cartelization was encouraged for various other reasons. So what then happened is that post-1994, after the advent of the new democratic dispensation in South Africa, the new democratic dispensation was then faced with this legacy and these challenges of an economy that has been functioning in a particular manner. And it has been quite difficult to change the mindset and to change how the economy has functioned before. So, for instance, in the case of the cement market, as an example, the cement production market in South Africa has been functioning as a cartel since the 1940s. It was a legal cartel. So after 1995, the legal cartel was disbanded, which means that for the first time, you have a market that does not know how to function independently and competitively, now having been forced to do that. So the end result was that even after the demise of the legal cartel, we saw a recartelization by cement producers, because that is the only way in which they have been operating for years. That's the only way of business that they knew. So then that is one of the biggest problems that we as competition authorities in South Africa are facing, that there is this tendency to recartelize the market, because that is how the market have been functioning for many, many years. So the cement market, I think, it's a very good example of that tendency in the economy to recartelize. The same as if you look at the agricultural production market, that market was also heavily regulated and under control various control boards. Various agricultural products were controlled by agricultural boards. So then you have deregulation coming into being and the market being opened up. Then again you see a recatalyzation even in the agricultural production market. So those are the, I think structurally, the challenges facing the South African competition authorities going forward. We have intervened, of course, in various sectors of the economy. And our interventions have been principally driven by the philosophy that we have to intervene in sectors that have an impact on consumers, in particular low-income consumers. Because for obvious reasons, our country is characterized by structural inequality, and we've got a high population of people who are who are poor and are low-income consumers. So our interventions are driven principally to address those industries or those sectors that have an impact on those consumers. We have also intervened in the banking sector, in the cement production market, as I have mentioned. We have also intervened in the steel production market. One other feature of our economy is the fact that you also have a phenomenon of companies which were previously state-owned, and post-1994, some of these companies were then privatized. So obviously, because of the previous position that these companies enjoyed in the economy, they tend to be super dominant because they were previously owned by the state or controlled by the state. ArcelorMittal is a case in point of a company which is now an international company, which was previously state-owned and was later privatized. Currently, we have got serious issues with their pricing policy because their pricing, the South African competition legislation, in fact, has excessive pricing provisions or provisions that are aimed at addressing excessive pricing, unlike other jurisdictions such as the US, where excessive pricing is not seen as a problem. In our jurisdiction, it is seen as a problem, and we have intervened, although the case has not yet been finalized. In the case of ArcelorMittal, which is basically pricing steel at import parity price, as if the steel is being imported from China. We have also intervened in the natural gas market, where we also have a monopoly in the form of Sasol, which also used to be previously owned by the state, but is currently a monopoly in gas, but has been privatized. So these former state-owned enterprises, they tend to assume quite almost a super dominant position in the market, and their pricing tends to be quite high. One important feature of our system, competition regulation system, is the fact that we don't only focus on what one can call the traditional concerns of competition law or competition policy, which is about efficiencies or effective functioning of markets. Our competition law system goes beyond that and also focuses on the public interest component, because although our system is based on or borrows from international best practice, but it has been molded in such a way that it should be able to respond to the local dynamics in South Africa. So that's why there's a very huge public interest component in our competition law regulation. And this public interest component is particularly prominent in the sphere of major regulations, where we, in addition to considering whether a measure will substantially prevent or lessen competition in a market, we also consider whether the measure itself will result in job losses. That is one other feature of the economy. We've got this a very high rate of unemployment. So when we look at M&A transactions, we also look at as to whether the measure itself will result in job losses. And where a measure will result in job losses, we do intervene by way of imposing a moratoria, very temporary moratoria of 2 years at best, to preserve job losses within a measure, within the measure context. So that is a public interest feature of our measure regulation system, which has now come to become accepted. Our system currently, in terms of cartel enforcement, is it's an administrative system in the sense that the sanction that is imposed for cartel behavior is in the form of a fine. So we have imposed throughout our existence, we have imposed fines on companies. But there was a realization that because this cartel behavior is entrenched, perhaps there needs to be a stepping up of the approach. So we have begun to move towards criminalization, but on a progressive basis. So there are criminalization provisions which have been introduced into our system. The criminalization aspect are targeted principally at the behavior of directors and managers of companies that engaged in cartel behavior. So if a director or a manager of a company somehow facilitated or contributed to the company or the firm engaging in cartel or collusive behavior, that behavior of a director or a manager will now, going forward, be subject to criminal sanctions. However, the legislation that has introduced the criminalization aspects has not yet been, although it has been passed into law, it is in a sort of state of suspended animation, because it still has to be implemented, because there are various systems that still needs to be put in place to ensure that we have the framework to implement the criminalization aspects. I just wanted to quickly touch on the healthcare aspects, which were touched on by the guest presenter. We have also intervened in healthcare. The South African healthcare system it's a dual system, because you've got the public sector hospitals, which are owned by the state, catering primarily for the poor as well as low-income the low-income sector. And you also have the private hospital sector, which mainly caters for people who can afford private health care. So there is that division in terms of the provision of health care. However, the private healthcare sector is quite expensive and quite unaffordable even for people who are already in the system. So we have intervened in the private hospital sector by way of a market inquiry, which is currently going on, and we hope that will be finalized. The market inquiry will be finalized next week to look into the state of competition in the private hospital market. The sector, like most features of the South African economy, is it's really heavily concentrated, dominated by about 4 hospital groups. We did intervene in the area of medicines through the single through pricing, some form of pricing regulation, but that is being administered by the Department of Health. There's a single exit pricing system which regulates the maximum pricing for medicines, but that does not fall under the control of the competition authorities. It falls under the control of the Department of Health. So in the main, our work in terms of the direction that we are looking at, in terms of competition policy and enforcement, we are looking at a direction where competition law as well as competition policy should be able to contribute towards certain, at least make a contribution towards the key macroeconomic objectives that have been set by the state, which is to promote inclusive growth as well as transformation. So we are currently molding our enforcement framework such that it is able to respond to those key macroeconomic objectives that have been set by the state. So our view is that competition law and policy, although drawing from international experience, should be able to respond to the peculiarities and the dynamics in a particular country. Thank you.
Thank you very much, Mr. Mayonge. After listening to your presentation, we now understand that between Russia and South Africa, there are many commonalities, many common things in terms of the approaches, economic approaches, legal approaches in regulating these kind of relations. But now I'd like to invite the audience to participate in the discussion so that you're not getting bored. Let's listen to people. And we've listened to 2 presentations from regulators, Igor Artemyev and Mr. Mayonge. And now I suggest you to ask questions to them about the things you've just heard. Please, a couple of questions we can take now from the audience. Yes, can we get a mic, please? And introduce yourself. My name is Mr. Shret. I am a lawyer from Moscow. I represent the Bar of Moscow. Igor, 2 questions to you. The first one is purely legal, purely a question from a lawyer. Have you ever had a practice? Have you ever had a case when a business responded and performed your recommendations and then went to court and tried to argue with your decision? And did you have ever a need to bring 2 matters to court and 2 cases to court for one business? And the second question about limiting the IP holder rights. As far as I understand, you can do this for state reasons and for state needs if an IP holder is acting indecently in a particular market, or in this case a Russian market. So, to your mind, this legal framework, the legal backdrop of such a position of the Federal Anti-Monopoly Service of Russia, is it so because you want to protect the state interests, or do you want to really punish and bring up good and loyal businesses in this market? Thank you very much. Well, if you think, and if you're prone to suggest that we are trying to punish and bring up good and loyal businesses in the market, I'd like to say that it's too late to bring up these kids, because you have to do it in the kindergarten. After the 10th grade, you can't really influence these guys. So we're not doing any upbringing or any training. We are implementing legal practices in the market. And the second question is the Constitution. Public interests there to protect the people. And imagine an IP holder is crazy and is not supplying some vital medication for people, and the people are dying. What we are just missing here is the driving belt, right? So who's going to drive this whole machine into action? And that's what we need to describe yet. The initiator, well, we know that there's some global practice available. Very often such cases are they're going hand in hand with a limitation of competition. But if the government decides that it's not the Anti-Monopoly Service that should guide this and should govern this area, let it be another body, but it should be there. We need to have some sectoral regulation. We know that the Ministry of Healthcare can deal with medications, the Ministry of Industry can deal with some industrial things, some important, I don't know, vital pieces of a machinery that just cause all the machinery to stop and not work. The courts are very just, and I think, well, they've decided that this is arguable, right? Because although preliminary we say that in a particular business actions we can see some violations of regulations and norms, and we still give some time for them to improve the situation. But if the court says that there were no precursors of violation, and we say that there are, we need to launch an investigation for this. Well, when you argue the subject itself, it doesn't give you anything. An IP holder just discredits a very liberal practice there. We go away from forcing, and we are moving towards prevention, towards warning. And you can really start thinking about it. You can go to court with us, you can not go to court with us, but in 80% of cases we see that a warning is being carried out, because we're usually dealing with very simple cases, such as getting connected to a gas pipe for a business, getting connected to electricity grid, and so on and so forth. And we have thousands and thousands of such cases. Getting connected to a water pipe. Water is vitally important, and if you don't have electricity, try to survive in a 40 degrees centigrade heat out there without electricity or water. So a business really, when getting such warnings from us, understand that they have little chances, and that the punishment, if it comes, will be a significant one. Another case and another thing, can we really start an administrative case and find someone for somebody going to court? No, of course not. When people go to court, we never get upset, actually, and when they bring us to court, we never get upset, because this is a normal practice. It's better than if you just go to media, you start, I don't know, showing dirty laundry and shuffling decks of cards and clotting the ether with dirty things. So let's do it in an adult way. If sometimes an adult person needs an upbringing and needs training, we'll do this. Sometimes we're just there to protect the image of the government. So we're not getting upset if somebody goes to court with us. If we find that this business is still to blame, we'll punish them. Okay, thank you very much. Any other comments, ideas, questions? Mr. Rogachevsky, representing the Baltica Brewing Company. First, Sergei said that one of the objectives of our session today is to find the limits of our legal practices. And I think you are already approaching an answer to this question. Igor, let me ask you a question. You've mentioned in your presentation about the possible changes in the law, in the competition law and IP holders, and you were talking about patent holders, but you are not talking about trademarks, right? You haven't said anything about trademarks, so can you please elaborate upon that? And second, do you synchronize all these steps with our partners from the Eurasian Union? Do you do this in parallel with them? We've established this common economic space, and that's and definitely all issues related to intellectual property, goods turnover, trademarks, everything that's dealt with IP, not just can be discussed with our partners with this customs union or in this customs union, but had to be discussed with the customs union, and we have to have a common approach. And just recently, there's been a big meeting with our prime minister, and a question with this IP thing has been resolved basically there. We will start a step-by-step liberalization of the market. And the question is already decided on. The Anti-Monopoly Service has been advocating this issue for 10 years. We wanted our entrepreneurs to legally buy certain goods abroad and to bring those goods without the consent of an IP holder to our country. Such decisions are already being organized. They will be more of a limiting, recommending character, so to say. Those companies that localized their production in Russia, such as brewing companies or Baltica, right? Baltica built a lot of plants. Unfortunately, they closed down one plant, which upsets me quite a bit. And this thing and everything that I told you about this forced patenting as a radical measure, it can only be discussed and it can only be done in conjunction with our partners of the Eurasian Union. And it's actually our country that was very firm, and Armenia and Kazakhstan, they had this international principle of exhaustion of rights. They had to introduce another principle, and they still believe that it's a loss for them because they now can flood their markets with cheap and quality goods, and the fact that we're moving towards this, you know what I'm used to tell to my colleagues about the parallel import? Well, there are people who work in our service for 20 years, it's not me, but others. Well, I'm telling them this parallel import, the inclusion of this principle, however you judged your work, however you looked at your life, it's actually half of your life job. Taking off those exclusive monopolies who are like a Damocles sword over our country, setting prices, huge prices for everything, medications, OEMs and whatever. Then the first stage of liberalization in the framework of the customs union, and starting from today, and that's another news, from today we got a right to discuss this. And I know that Igor Shuvalov is currently discussing this issue in Astana. He is the first deputy of Prime Minister, and he is also the head of IP in the Eurasian Union. He discussed these issues of parallel import, intellectual property. He's now doing this with our partners of the Eurasian Committee and the Customs Union. And I hope and I think that this process is going to go forward quite fast. This is a mini revolution we're living through in a good sense of word. You know that there are many opponents to this idea in the country, but I hope that our citizens, well, the citizens are our major ally, because they vote with their feet, they vote with their head. And they want demonopolization. Demonopolization is extremely important for us. So that's the only approach we can take. As for the trademarks, yes, trademarks. Sergei, article number 14. Sergei Anatolovich will be able to answer more promptly. We're not talking about the fact that the trademark will be extorted from someone and given to somebody else. We can only use article 14. Illegal competition. Two more questions, please. Good afternoon, Nikolai Voznesensky, BLP. Igor, about IP. From your presentation, I found out that you have this concept. You think that there are two markets, the commodity market and the technology market. And you said that the court practice has decided to move along a very right way, and Court practice says that there are no limitations and you can use anti-monopoly law to the commodity markets. But then you moved over to the technology market and you talked about licenses and you talked about amendments in the code. Do I understand correctly that technical markets are not going to be regulated by law but by the competition law? And through the civil code, through the amendments in the civil code about this forced licensing, forced patenting, and the role of the anti-monopoly service is going to be limited by just an opportunity to apply to court. And they can will not be using Article 11 or 10 for not transferring licenses. Well, will technology markets be taken out of the anti-monopoly law, and will they be governed by the civil code, basically, of Russia? That's first question. Second question, do you think that there's a possibility of industrial specificity? You've talked about medications and drugs. In the Eurasian Union, in the European Union, there's a directive that can allow forced licensing in those countries where there's some problems with health and medications. Can our country follow the same path? Can it also do forced licensing for some special products, for example, pharmaceutical products? Thank you. And thank you very much, Nikolai. Yeah, the things you call technological markets, this thing you call a technological market here, the anti-monopoly body can only serve as an initiator, not a true regulator. And that's why we have to consult with you, with our esteemed colleagues, in order to really find our stand, because the political decision is there, the political will is there, and it's going to be discussed in the government, but we still haven't resolved the way it's going to look. It won't be described particularly in package number 4, so it won't be something out of the blue for you. We are here just an initiator, and you are exactly right. Probably everything will be fixed in the civil code of Russia. That's first. Second question, I think that there should be some specificity, industrial specifics. For example, there's some very sensitive industries related to health, to safety of people. There are less sensitive industries, and I think the specifics has to be taken into account. For some industries, we can't have any cases of forced patenting, because you are not dealing with any threats to life or security of people and so on and so forth. So a very closed list and a very narrow list of industries, and we have to be very careful when presenting the wording. We must definitely consult with judges, and this work will not take 1 year. It will take much longer, and we'll definitely have to look over our shoulder to BRICS countries, because they did something like this, and we want to do something similar, and this will lead to harmonization, and we'll definitely discuss best cases, and we'll definitely have to discuss this situation with our colleagues from the Eurasian Union, those 5 countries, because we need to convince them to make additional steps towards one single goal. Well, that will be some homework to do, but we are moving from discussions to realization. How much time it will take? 5 years, to my mind. Thank you. 2 more questions we can take, and I see 2 hands, and at that we will wrap up this part. Good afternoon, dear colleagues. My name is Roman Berdanin. I'm from Kazakhstan. A question to both speakers, because they're representatives of regulators in here. So the main function of an anti-monopoly body is to protect competition, but an anti-monopoly body, as any representative of the state, whether it wants or not, has to deal with social functions. So how just and how justified is this? And if it's justified, where to find and how to strike a balance? Let me give you a Kazakh example. For example, we have a practice when we can sign a memorandum on not raising prices with businesses. What's your opinion on that? Well, being a part of the government, being one of the bodies of the government, we represent the state. And if the state doesn't think about its people, it's a bad state. And there's several ways of regulating it. An anti-monopoly law, and it has to deal with a very specific part of our markets and economy, monopolies. Monopolies is a very hot sector. I remember when we lived in the Soviet past, it was a norm, but now it turns into practice, bad practices rather than good ones. So we definitely must think. And sometimes we not say people, we say consumers. However, the right thing would be to say people. We're thinking about people with all their needs, with all their concerns. I think it's a more humanistic approach. But of course, this person buys goods, right? And then he's called a consumer. But this person, when he buys goods, he needs to be left with some money to pay for his medications, to pay for his for education of his kids, for his housing, and so on and so forth. And definitely, well, it's the parliament who decides what to spend on social things. Our main objective is enforcing law, fighting off bad practices. But all these things lead to social effect. When large companies, you know, there are some political officials who are libertarians. They say, don't touch large business because large business brings us progress. And I'm not for this theory because large business, well, is too big to fail, right? If they don't have a good stick that's beating them, sometimes they turn to oligarchia. And as far as I remember, those large corporations and large companies, they just wanted to sit on the top and rule everyone. Well, when there are new humanitarian ideals embedded in the heads of those oligarchs, I think these big companies will change. But there's no limit to people striving for wealth and prosperity, and there are too little and too few of those oligarchs who are really charitable persons and contributors. So it's better to redistribute the wealth for other industries also to strive, such as healthcare, education, and so on and so forth. So we must think about it. And if you look carefully into our law, you'll see this practice of reason, and this practice of reason allows us to be more effective and efficient when dealing with social issues, because my colleague from South Africa has said it rightly, because if we allow merger and acquisition, but then 10,000 people lose their jobs in a city with 10,000 population, then the riot starts, the city starts rioting. So you should prevent it. And before, well, they said about 2 years. Well, we want to see the program for 2 years, and we have to be convinced that the resources are going to be redistributed in such a way that people will have jobs. You shouldn't be really doing anything else. You have to be reasonable, and this allows us to be quite specific and quite flexible. However, there are some special tasks and special objectives. Of course, you cannot fine a company for them not paying salaries. There shouldn't be in anti-monopoly law. I also want to give the floor to Mr. Mayonga, please.
Yeah, I think this is quite an important debate and an important question that has been posed. Yeah, unfortunately, you know, the answer to this question really depends on what your perspective is on the issue. Because if you approach the issue or the question dogmatically, to say that the sole and only objective of competition law or policy should be about efficiencies and nothing else, then your answer to the question is likely to be different. But if you approach the question from the perspective of saying, and I agree with my Russian counterpart in this respect, from a perspective of saying you have to consider the issues holistically. So I do agree that there has to be a recognition that actions or decisions made by corporations do have social consequences, and that competition law or policy cannot conceptualize away from dealing with those social consequences that are brought by decisions of corporation, in particular those decisions which fall within the domain or the realm of competition law. So it's quite a complex debate, because part of the argument against bringing in the public interest or the social element into competition law Part of the argument against that is that by bringing in these social aspects or public interest aspects, that imposes a cost on firms, which undermines efficiency. So I do agree that there is a tension between efficiencies as well as social object. There is definitely tension because a cost definitely is being imposed on firms. For instance, in our case, within the context of merger regulation, when we imposed a remedy that there should be no job losses in a merger context, that obviously imposes a cost on the firm, which obviously may to some extent undermine some of the efficiencies which are sought to be realized by a merger transaction. So there is that tension which we cannot unfortunately run away from. But the key issue is how do you manage and strike a balance between these two competing interests. Thank you.
Thank you very much, Igor. Yes.
I will provide an example for you. This is no secret. We never try to set a certain price. This is prohibited in Russia, and this is prohibited for all the authorities. Nevertheless, we have to take the social aspect into account. In the formulae of the world prices, there's always a variable ratio that is translated into internal price depending on the economy, and we cannot do otherwise because otherwise we will reduce the efficiency of. But when we are talking about, for instance, the social aspects, when we are talking about the import of fertilizers, which are of vital importance to the agriculture, yes, we said yes. We will buy at the lowest price in the world market. With fertilizers, the cheapest fertilizer is produced in China, but it's a huge market and has about 30% of the world market of fertilizer. And we agreed with such a formula because people knew that this is the global translation, that this component has 92%. 92% of that is world price, and the fact that we lowered this price is by 8% because this is of critical importance for our market. So there must be a variable, but there must be a coefficient recalculating it for social aspect. And we can use such formula and use it for many years. I think in fertilizer market such formulae have been used for 7 or 8 years. And this is probably the principle of reason in it. Colleagues, I apologize. The last question, please, because we are running out of time. Thank you. Konstantin Lebedev, St. Petersburg State University. I also wanted to attract your attention to your presentation on prices. That is very important in struggling against cartel. But how efficient are you? Judging by the commodity markets, you are not very efficient, and there's an impression that the Federal Anti-Monopoly Service doesn't have a concept concerning regulation. We certainly have price regulation concept, and it is embodied in our basic documents, but we are not a price regulators. We are not going to regulate any prices at all, except by market methods, by writing down the best practices of the companies, but special investigation may demonstrate that there is a violation of law, and then there might be an accusal of monopoly high prices, but the dominating companies have to regulate themselves. We are allowed to do everything. We can use any prices that we want. As for the monopoly companies, we have to regulate them. We haven't achieved the best results, yes, and there is one recipe in the world practice. The results are achieved by rare investigations, very serious investigations, and by placing the directors of such corporations in prison. And in witness of that, I would quote real cases in the United States when managers were put in prison for up to 5 years. And when this happens, people start thinking, no, I don't want that. I might lose money, but I don't want to go to prison. And we are living in a condition when last year we had the first suspended sentences on Article 178 cartel violations. This year and the next year will be a decisive year, and then we will be efficient. Yes, we cannot boast of much right now. Thank you, Igor. We want us to make some progress, and before passing the floor to the next panelist, I want to say that the efficient anti-monopoly policy depends very much on the efficient sanctions. And the efficiency of sanctions depends not only on the antitrust bodies, but on the judicial system, because the enforcement of law depends on all of the state machine that is using that law. Russia is traditionally believed to be a country with predominantly Roman and German law system, when a precedent is not recognized as a source of law. However, in the anti-monopoly regulation, everything is not that easy and simple, because a lot of court rulings and judgments are sometimes stronger than the law. And in anti-monopoly regulation, you have lots of such examples. I would remind you that the plenum of the Higher Arbitration Court in 2008 may be called a separate anti-monopoly package, because it was a very important document explaining a lot of economic issues, and it really brought together a lot of different regulations. When a lawyer is asked what an excessively high price is, a lawyer cannot answer that, but the economist can. So we need to find the regulations that will allow us to do that. So it is my great pleasure to pass the floor to Oksana Gvozdilina, the former judge of the Higher Arbitration Court, to listen to her opinion about how the judicial practice must develop and what is its impact on anti-monopoly regulation. I'm glad to welcome everyone in this room. I would like to request the organizers. I think this room is too small for the audience. I'm sitting opposite the entrance, and unfortunately people are entering and leaving. I think for such a session, this room must have been much bigger, because this is a very interesting topic. Even the Eurazes judge was standing here and then failed to find a seat and left. As for the presentations before, the previous presentations, certainly they shed light on the ideas of everyone in this room, that there is a balance between the social, and that there's a very thin boundary between the efficiency of anti-monopoly law and the social aspect. There's a lot of examples in literature of unfair competition. O. Henry is perhaps a classical author of that, because you could read any story by O. Henry and find examples of unfair competition. And Mont Oriol is another book dedicated to unfair competition. It's dedicated to tourist business and how this business sprang up in France and what unfair means were used. A lot of classical authors wrote about unfair competition. Adam Smith spoke quite a lot about it, and in particular he said that representatives of one type of trade very rarely get together even for entertainment, so that that meeting doesn't end in a conspiracy or an agreement on prices. This is a very old saying, but it's still valid. And the secret of success is being fair and honest. And that's another saying. And I think they reflected very well in Article 14, which is undergoing amendment right now. There are a lot of ways of unfair competition existing worldwide and in this country. If we look into the classical violations, so to say, we could find examples of price agreements, abuse of market situation, setting monopoly prices when monopolists, with a flourish of their pen, establish monopoly prices. Previously, such agreements, such cartels were set up quite legally, but ideal competition does not exist either. And many people ask whether competition needs to be regulated, and quite a lot of people are pessimistic about it. Not in this room, but in other places of this forum, there were meetings from different European anti-monopoly and antitrust services, and when I listened to them, I had an impression that this was the most important issue. How to find this thin boundary between the social aspect and the efficient economy, between unfair competition and intellectual property. A whole lecture was read by the head of the OECD competition agency, and there was a lot of discussion what is more important, the social aspect or setting the rules for fair business. And Theodor Tanner spoke about the same as the head of the competition agency of Austria, and he also set the question whether you should protect competition or the market will regulate itself. And many people asked that question. Quite recently, a book by Rockefeller was translated into Russian. It was not the book by that big Rockefeller who said competition is a sin, but by another Rockefeller who worked in the US antitrust service, and he was very pessimistic about regulation. And he said that anti-monopoly regulation is harmful to the market and it's a sin. And that was written by a person who was one of the founding fathers of the US anti-monopoly service. And I believe the book's name is Antitrust Religion or something like that. But I don't believe we need to be pessimistic. If there is unfair business, it needs to be regulated. Whatever the status of law as of now, maybe it's somewhat deficient. And that's the opinion of all the people in all the countries. Everybody says that there are deficiencies in regulating In some countries, the regulation is insufficient. In some places, the situation is over-regulated. And of course, this country also has its own deficiencies. Given the rapidly developing legislation, I believe the fourth package, with the eighth package, the 10th package, when I read the fourth anti-monopoly package, I understood that the initial package has been reworked, so it's not recognizable. There's not a stone set upon stone. And the most important thing is that the sphere of warning is extended, and that is certainly an achievement. But I like that saying, if you ask a businessman about the most pleasant sound in the world, it is either the jingling of gold or the thud when your competitor falls dead. And I believe that this warning system that embraces all the spheres, well, I didn't hear anything about advertising, which is part of anti-monopoly regulation in Europe, and I believe that this was a pleasant news. But what I was dissatisfied with, that mandatory mitigation procedure has fallen out, and mitigation is now not obligatory, but at the discretion of the parties. Well, certainly the courts expected the mitigation to be obligatory, because it works very well in the tax law. I've been dealing with tax laws for 15 years, and I saw how all that happens. And in my opinion, mitigation was a very positive feature. Well, I understand the difficulties of the anti-monopoly service. Probably it's because of lack of resources, but it's a pity that mitigation has fallen out. The anti-monopoly package is very big and has undergone a substantial change, and I believe that the sanctions have been much better formulated, and certainly this will be of great value to the business community, to the entrepreneurs, because in my experience there were a lot of cases and problems related to some arguable issues when inspecting businesses. So I believe this is the correct thing. And what I like very much is that Article 14 has been extended, amended, and I believe that it's a good thing that now it has a list of all the existing violations. Well, the interpretation of that may be broad, but I think that's right. I think Churchill said once that if there's over 10,000 prescriptions, the law becomes inefficient. So we shouldn't overdo it. Not all of the problems have been described in that package, because what I didn't see in that package was the relation between the routine and ad hoc inspections and the issue of lawsuits. But I think the issue is quite ripe, and these problems will come to the forefront, will be dealt with, because the law reflects what's happening in the society and reflects all the legal issues that each of us faces every day. I want to notice another thing, the EU directive on unfair businesses focuses on the consumer. Even that directive has that exception. That directive does not regulate the issue of relationships between companies, but it only comes into force when we are talking about the consumer. In my opinion, in the Russian law is different in that aspect. The rights of the consumer are regulated by another law, although there were cases quite often when Article 10 was applied, but the question was whether Article 16 on the protection of consumers should have been used. Coming to an end on the subject of legislation, recently I've been thinking, isn't it the time to codify our financial regulations? Like the inspections, the tax code regulates the procedure of inspection very, very clearly. The customs code also regulates the procedure of inspections. Both bodies are very similar. All the three agencies are actually very similar. They look at the market price. They perform the same inspection functions. There's a lot of similar issues with their procedures, and probably it's a time to codify all that, to write a kind of a financial code, not to reinvent the wheel. Because in the sphere of competition, every regulation ensues from the already existing laws, and probably we should unify all the inspection procedures in one code. For instance, we are working on the municipal control issues, and they are also trying to regulate the antitrust agency inspection procedures. But I think all those attempts would result in a codification of financial laws. Maybe I'm looking tens of years ahead, maybe I'm wrong. But maybe it's because I dedicated 20 years of my life to antitrust, monopoly, customs and tax issues. And to come down to practice, there is another saying that law enforcement is more terrible than law in Russia. And when a new law arises, the law enforcement practices may be absolutely different, and its concentration in the higher arbitration court has been reaching huge numbers. About 70 cases, purely anti-monopoly cases, were considered by the higher arbitration court within the last 10 years. And there were issues with market boundaries and the relationship between monopoly in one market and a monopoly in another market, and the overlapping markets issues and economic entities in those markets. And there were a lot of issues with dominating position in the market. There were a lot of cases under Article 11 and different prohibited agreements, which were not called cartels at that time. You could recall cases on alcohol cartels in Kemerovo. And certainly, when the courts faced such cases for the first time, they tried to use the civil code, and probably that was not quite correct, because when we're talking about a prohibited agreement, and I recall the world practice, I recall O. Henry described that if a paper is signed, it doesn't mean that this is a transaction under the civil code. And if all the alcohol businesses in Kemerovo signed an agreement on a single price, the civil code does not regulate that. And there was another case. in Orenburg, the Orenburg Alcohol Union, where the court tried to formulate the approaches to the evidence. There was the Angström case, which touched upon the IP issues in microcontroller market. That was an old case. So there were quite a lot of cases under Article 11, and one of the recent ones was when the anti-monopoly agency used Article 11 and 14, and that was a case on domain names. And the Presidium of the Arbitration Court tried to formulate its position and approaches not only to this weakly regulated market of domain names. It's weakly regulated not because the legislator doesn't want to regulate it, because we cannot regulate it, because the domain names do not belong to the country, and we simply cannot regulate them as much as we want to regulate them. But nevertheless, the Presidium tried to formulate certain approaches based on the rules for the distribution of domain names, and to formulate the unfair approaches to registering domain names, and the administrators should not mix their public function with their economic function. Although there were quite a lot of other issues, but today I wanted to speak just about those ones. But when we speak about the relationship between IP and competition, one should recall the cases under Article 14. The very first case, loud case, was all about the Pyaterechka chain in X5 chain in Tatarstan. It was a case on unfair competition. I would recall this case because walking on the streets of St. Petersburg, you do see those stores that look absolutely similar, and probably there is an element of unfair behavior here. Because this case was considered based on the specific circumstances of the case, when the regional anti-monopoly service was too lazy to find the evidence of unfair competition, and they just interpreted the agreement on a concession, and the right owner could not come back to the market just because there was a clause saying that the third parties are not admitted, but there was no evidence apart from the concession agreement, and the court failed to prove unfair competition. And at one of the conferences, my American colleagues told me of similar cases in the US and Australia, and you can see that in other countries the antitrust services look very closely at retail chains. When a supermarket is built on the one side of the road and then another one, the same supermarket, is built on the other side of the road, and that is seen as a violation of antitrust law and an indicator of unfair business practices.
Now, touching upon some other countries, we've been to many conferences and we've heard about many different examples, American and European, but I haven't heard of a single case, any single case of anti-monopoly law violation that would be similar to our court practice. There, legislation is so active and so fast developing that we have to catch up with them. And when we were dealing with the domain case, we found a domain case in America, but I think it was dealt with by one single court of arbitration, or in New York or whatever. It seems that violations are all similar all across the globe. It's just that the anti-monopoly bodies have to learn from each other. And I think the way we think, the way people think, is very similar. I think it's Shakespeare's word that people act like fish, small, big eat small. And I think the big it eats the small. And I think anti-monopoly law violations are all similar across the globe, but there are different approaches being used, different approaches to regulating the market, different approaches to monitoring the market, and the way these cases are brought to court. If we look at Europe and if we look at America and the US, those countries where the law has been taken from by our country, at least some of the clauses to our regulations were taken, they have a very interesting court practice, civil cases, civil practice. In Russia, we have mainly administrative cases, and the decisions of anti-monopoly services are being argued in court. In the world, it's a little bit different. I remember when Europeans were really surprised. What does it mean by arguing the decisions of a body? A body needs to come to a court and it needs to argue that there's been a violation. Well, that's the way the Russian legislation is built, but now some civil cases are being brought, some charges are being brought in the civil law, and Yuri has told us about it. Anti-monopoly bodies want all these things to be written in our civil code about the possibility of going to court with civil cases. There's actually such a right already available. You don't have to inscribe it in the civil code. Each party, if it sees the violation of competition, it can go to court and can go to court and can use civil proceedings. For example, arguing certain contracts and so on and so forth. It's not forbidden. It's not banned. But the anti-monopoly body thinks that if this thing is written in the law, they will have less work to deal with. But we have a different mentality here. You see, it's easier for us to claim for something. Well, for example, technological merger, right? It's been heard at our presidium, we've listened to it, it's passed, and people think that as soon as this case goes through us, there will be a mass of cases going through court, and that people would see, well, how efficient it is, go and make your claims. And then it would seem that a particular consumer and a particular customer gets a clear way of resolving his problem. But I think the warning system here that you've instilled is quite an efficient one, and it will help a lot. Now, I'd also like to touch upon the issue of warnings and arguing against warnings. Actually, it has been a very difficult problem, but I think when we completed our last hearing, there's been a decision made by our presidium about the limits by which you can argue against the warnings in court. So the presidium argued, and the presidium stated that you can argue warnings, but this things are very formal, because the court cannot decide for the anti-monopoly service about the body of the case. It will just formally check all the main characteristics and all the main things that served as a basis for issuing the warning. What's about time? Am I about to wrap up? Okay. And I can say lots and lots about that, but, well, for 5 years I've been dealing with this category of cases, and I can really go for a long time. But in the end, I'd probably like to call you to deal with this topic more, because the topic is extremely interesting and very topical, very timely. Our legislation is trying to run in front of the locomotive when seeing some very good practices somewhere abroad and trying to implement it here in our country. So our legislators are trying to copy the world's best practices, but it doesn't work well all the time. And the more our science, the more we deal with mathematics, the easier it will be for our government, for our anti-monopoly bodies, for our courts, and in the end, I hope that we will finally get this norm of regulating these things in court, probably in your 5th or 6th package or whatever other package you're planning for. Thank you very much, Oksana. Igor, do you want to add something and comment? Let me be just very brief. First, thank you very much for the work you did, for cooperating with us for this long time. And we do remember those brilliant cases that I think found their way to textbooks, that the High Court of Arbitration presided over. But there are two things I would like to say, maybe a little bit of a joke. You've said about Mr. Rockefeller, not the big one, but the small one, who got very upset about some things, and you said that he published a book. And you know who published this book in Russian? One oligarch comes to me and says, there's a book in Russian language, we've produced it and published it for you to understand that what you're doing is nothing, and we send this book to all the entrepreneurs in Russia. Apart from Alan Grispa, who's a libertarian who thinks that anti-monopoly law is useless, there's another person, Rockefeller. And our oligarch spent his own money to translate his book for us to read it and understand that what we're doing is nothing and is useless and is worthless. And there's another joke. I think the government is doing a very important thing. It's now preparing the list of KPIs for all the heads of various departments. And I have just one KPI. The number of decisions of anti-monopoly body that's been cancelled by court, and I will be fired if this KPI is not in line with my government's expectations. So I'm referring to you, to the court. So let's do something that I'm not fired, or, well, do something that I am fired finally, because if you think that for 11 years we've not been doing whatever we need to, be more serious about us and be more strict. Actually, not just the Federal Anti-Monopoly Service has been given KPIs, but many other bodies have been given KPIs, because KPIs is a very good criteria, because this criteria that I was just talking about, that we cannot influence. Others we can. This one we can't directly, I mean. So what's the outcome of this? We will be more thorough when preparing to court cases, not to make mistakes, any mistakes. Thanks a lot. I'm exhausted my time. Thank you very much. And on that optimistic note, I'd like to announce for a break. A break will last for 30 minutes from 12 to 12:30. So at 12:30, we will reconvene back in this room, and we will continue. We'll still have 5 more presenters to listen to. Thank you.